Next pitfall, not checking beneficiary designations and account titling. So far, we've talked about a will and we've talked about revocable living trusts. So a lot of people think, okay, I did a great job. I've got my will in place. I've got my trust in place. And they think that's it. That's all there is to it. They're taken care of. They're covered. All is well. One of the benefits of working with an estate planning and elder law attorney is they'll say, let's look at what all your assets are. Do you have a life insurance policy? And somebody might say, yes, I do. Then the life insurance policy should have a direction on it that says, on my death, this life insurance policy pays to whomever. That's called a beneficiary designation. And that makes things way easier because the will and the trust might say something very different. And these assets are typically, well, a will doesn't take effect until death. A revocable living trust takes effect when it's signed, but it doesn't distribute assets to death. Let's look at another probably more important, or maybe more important asset, is your IRA, your IRA, or your 401k. So these are assets that pay by way of beneficiary designation. These are assets that are not put into your revocable living trust. So let's say you had a revocable living trust because you wanted to avoid probate, but you failed to realize, maybe because nobody told you, that you need to put a beneficiary designation on those assets because your trust isn't going to control them. So if you have a 401k, when you and your employer set it up, you'll remember that you filled out a form that says where it pays. So let's say you have it paying to one person and then you create a trust later or you change your trust and you want really all your assets to go somewhere else. Well, you're going to want to make sure that that 401k pays where you want it to pay, which might not be whomever you designated on your old beneficiary designation form. So it's important to realize that certain assets should pay by way of beneficiary designation, and they should be set up to pay to the proper person. Similar to beneficiary designations are titling of bank accounts. Not uncommonly, somebody will say, I'm just going to put I've got 3 kids, I'm single, I'm just going to put my daughter, who's my responsible person, as a joint owner on my bank account. And that's because you just want them to not have to have a hassle after your death, not be able to access the funds. And you count on your daughter to divide it equally with her 2 brothers, for example. That is setting up a bank account, joint tenant with right of survivorship, and it is setting up your daughter and your other kids for the possible litigation and disagreement about what happens. Because your daughter can easily say after you died, Mom set me up because I am her favorite child, and she wanted me to get that account, and clearly she did, because my name's on it as the joint owner with right of survivorship, meaning that account is all mine. Sorry, siblings, you're out of luck. And the siblings are going to have to say, but Mom's will says it goes equally to the 3 of us. And the daughter's going to say, and she's the one with all the money because she's got all that bank account, saying, no, Mom just put up that will to say to the 3 of us in case there was another asset, but this asset, that's mine. I get to keep that. What do you think will happen when money is involved and that position is taken by the joint owner? The likelihood is there will be litigation. When you hear the term litigation anywhere, and when you hear the term litigation involving an estate and probate and money, guess what? it is going to cost money. And the lawyers involved, which will be multiple, are going to charge a lot of money, all because mom tried to make things easier, not understanding the consequences, put the daughter as a joint owner, and created this opportunity for a problem. So what did mom do wrong? Did not get legal counsel. Legal counsel, people don't want to pay lawyers. I understand that. Rather than thinking of it as a cost, can you think of it as an investment, getting things done correctly so your family doesn't have a problem? Just a suggestion. Because doing it yourself, doing it on the cheap, doing it with a lawyer that does a general practice, does everything, might not provide you that level of service that is going to make sure that you have a good estate plan. I want to make sure that we circle back to the 401k, because this was an actual case in Washington State. So 401ks were created after ERISA, Employment Retirement Income Security Act of 1974, ages ago. Through ERISA, 401ks were created. 401ks are a creature of federal law, not state law. So here's an example of doing your estate plan wrong or not having good legal guidance. So let's say we have an individual who was happily married and he put his spouse on as the beneficiary of his 401k. Totally makes sense. Then life happened, they got a divorce. Okay. And maybe even the divorce attorney said, hey, client, let's just do a new estate plan. You're divorced, you don't want your wife being your beneficiary, etc., or, receiving your estate. But the family law lawyer perhaps didn't think to give guidance on, client, you should also change your 401k because it has your ex-spouse on it. So, and this is under federal law. Washington, by the way, tries to help people, honestly, tries to fix things such that if your will said, hey, it goes to my ex-spouse, and Washington says it's an ex-spouse, we treat that person as having died so the ex-spouse doesn't get anything, which is good. Not good that you didn't update your estate plan, but good that Washington tries to help. But you didn't update your estate plan, you got a divorce, your ex-spouse is on your 401k, which by the way, might be your biggest asset. Your house or your 401k typically are your biggest assets. So let's say you didn't update your beneficiary designation on your 401k, you die, your ex-spouse is named. Shouldn't it go somewhere else? Shouldn't Washington's laws fix your failure to update your 401k? Arguably it should. But federal law prevails. What that means is that guess who gets the 401k? The ex-spouse. Is that what the person who died, we call them the decedent, is that what they wanted? Not if they would have thought about it. Probably don't want that person to get anything, but they ended up with potentially the biggest asset. Not a good result. And so here's I'll call it a trap for a trap that people fall into, a pitfall, which is what we're talking about is make sure that your beneficiary designations go to whom you want it to go to. Don't ignore your 401k. Or any of these other assets that have direction. Don't set up I'm saying a lot of don'ts. Let me phrase it differently. Change your beneficiary designation. Make sure your bank account also is set up so that it doesn't jointly go to anybody. If you really want somebody to get more of it, say it in your revocable living trust or your will where it goes. Don't give joint ownership because that really sets up conflict for the future. So, key takeaway, please make sure that your assets are directed to go where you want them to go. realize that your will and trust do not govern all your assets.